my name's Alexia Rhodes. I'm the Learning Network Manager at the Good Employment Charter, and obviously I'm joined today by Karen Lester, who's the trainer at Acas. So these share and learn sessions in 2026 are focusing on the Employment Rights Act 2025 and all the new changes that are coming in this year, just so that we can update our network and share some best practice on the things that you can implement. So our session today is on family-friendly workplaces. So we're going to be talking about all the updates related to that and just sharing some good practice and things that you should be aware of. So with the introduction done, I'm going to hand over to Karen to lead on the webinar. Thank you.
Brilliant. Thanks, Alexia. So just a couple of housekeeping things for today. As I did mention, because of the settings on these webinars, you are on mute. However, that doesn't mean that you can't get involved in the session today. Please, if you've got any questions, do pop them in the question and answer box, which can be accessed on your control panel for Zoom webinar. If it's not appearing, you can you can access it through the three little dots where it says more. You should have the option for your Q&A box at that point. Okay, so let's get started. I am going to give an introduction. Some of you might be very familiar with Acas, some of you might be new to Acas and not fully aware of what we do. Before I start, Alexia, sorry, just to check, Alexia, are we recording already? Is that all?
Yeah, we're recording.
Excellent. Okay, fabulous. Okay, so let's get started with a little introduction to Acas and myself. So my name's Karen Lester. I am a trainer and advisor for Acas in the Northwest, and I spend my days working with employers and employees and managers and HR professionals on a very, very wide range of employment legislation topics, as well as a lot of best practice policies and procedures within lots of different sectors. Acas work really closely with the Charter in Manchester, and it's always a pleasure to join these sessions. So today's sessions is that kind of a catch up for the session on family friendly workplaces. We are going to be discussing the recent changes to some of the employment legislation, okay, that have come in this year because of the new changes to the Employment Rights Act. We're also going to look ahead and we'll look at some future changes, okay. There are some of the legislation that I will mention that are things that haven't changed, but I will give a little overview of those just to make and give that full picture of family-friendly legislation that is available. On the PowerPoint there, you will see my email address, folks. Please, please, please take that down. You're more than welcome to drop me an email directly if you ever have any questions on employment legislation. Okay, so I am going to pause just as the slides move through because apparently there's a slight delay in you being able to see them. So let's first of all start looking at some of the changes. But before we do that, one thing I want to really point out is that when we talk about this legislation, some of it sounds very technical and very factual. But what we want to remember at all times, whenever you are going to be using these pieces of law, the employees are going to be dealing with some really big life events, okay? Where potentially they're going through births, deaths, adoption. And we must remember that when we're conversing with our employees about this legislation, we've got to be confident in explaining the facts, but explaining them in that clear and concise way and in a way that's empathetic and understanding of the situation that they're in. And today we've got to remember then that as I talk through this, some of it is very, very factual, but it does cover some of these big life events. Okay, so these are some of the recent changes that have come in from April in line with the Employment Rights Act changes. Okay, and just as a little bit of a background, if you're not familiar, that in December 2025, the Employment Rights Act received royal assent and became law. There's a lot of R's in that sentence. So the changes that we're going to be talking about today have been implemented from the 6th of April 2026. So there was a lot of R's on that slide. There's going to be a lot of P's on the next couple of slides. So I will have to remember to talk very slowly and clearly. So we are going to have a think about then statutory paternity leave, and ordinary parental leave. But before we look at the changes, I'm going to give you an overview about what those two pieces of law are. Okay, so the statutory paternity leave gives the ability for fathers or partners to take 1 or 2 weeks leave after a child is born. This leave does attract statutory paternity pay if the employee meets the eligibility criteria. As I talk through some of these things, I'm not going to give you all of, for example, I'm not going to give you the eligibility criteria for this. But what I am going to say is just be aware that there is criteria that people have to meet to be eligible for the leave as well as for the pay. And you can find all of that extra information on the Acas website, and the details for that are coming at the very end of the slideshow. You can also find all of that legislative information on the government website as well. So prior to April 2026, employees had to have been employed for 26 weeks, okay? By the end of the qualifying week. Now, the qualifying week is the 15th week before the expected week of childbirth, okay? So that's quite a key date in terms of being eligible for some of these leaves and also for working out leave in terms of maternity leave, etc. as well. Okay. But since April 2026, this is now a day one right. Okay. So for parents whose child's expected week of childbirth was on or after the 5th of April, or for a child who's born or adopted after the 6th of April 2026. Okay, so that's statutory paternity leave. Now let's have a think about ordinary parental leave, and I'll explain that for you, and then we'll look at what the changes were. So ordinary parental leave is the right to take time off work to look after a child or to make arrangements for their welfare. This leave is unpaid in law. However, some employers do offer contractual pay for that leave. So always double check what's in contracts. Okay. Ordinary parental leave can be up to 4 weeks leave per year per child. And that's usually taken in blocks of weeks. Okay. Some employers may alter that. Okay. Because as always, we will explain what the law says, but employers can go over and above. And for a disabled child, parents can, under the legislation, take that leave in days. Okay. So prior to April 2026, an employee needed 12 months service to qualify for that leave. But since April 2026, again, this leave is now a day one right. Okay. So a day one right for statutory paternity leave and ordinary parental leave. Okay. So to be eligible for the ordinary parental leave, the individual must have legal parental responsibility. Okay. So mothers automatically acquire that. A father will also acquire that if they are married to or civil partner of the child's mother or jointly registered on the birth. Parental responsibility can also be acquired by a court order or a formal agreement with the mother. And don't forget also, guardians and adoptive parents also qualify. Okay. So both of these changes for day one rights bring these legislations into alignment with maternity and adoption leave also. One other change is that fathers or partners do not lose their right any longer to have paternity leave if they have taken a period of shared parental leave. And again, the aim of these changes is to provide more flexibility for employees to take advantage of different types of leave that are available to them. A little bit of background, I did mention shared parental leave there. Shared parental leave is where somebody who is on maternity leave can cut short their maternity leave and hand over the rest of their leave under the term of shared parental leave. If you need any further information on that, don't hesitate to access that on the Acas website. Okay, so the first change is these leaves are now a day one right, and that it's been removed that, or sorry, the restriction on taking paternity leave after taking shared parental leave has also been removed. Okay. Now we're going to have a think in a little bit more detail about these types of leave. So we're going to concentrate on paternity leave, okay? And we're going to think about some of the detail with regards notice periods that have to be passed, okay? So the employee is required to give notice of their intention to take their entitlement to this leave. Usual notice is no longer, is no later than the end of the 15th week before the expected week of childcare or childbirth, okay? Or as soon as is reasonably practicable, okay? This means that for those who were newly eligible from April, that there were interim notice periods from the 18th of February. Okay. So if a baby was born between the 5th of April and the 26th of July, the employee can give 28 days notice. Okay. We are obviously now coming close to the end of those interim requirements for notice. And at that point, then it will switch back to no later than the end of the 15th week of expected week of childbirth. Okay. Or again, as soon as is reasonably practicable. Um, the bottom box we can ignore now as the 6th of April has passed so that it's not relevant, but I have left it in just purely to address the situation that if a child is born early or prematurely. Okay, so if a child is admitted into hospital in the first 28 days, oh, sorry, I've gone ahead of myself there. Okay. Okay, next we're going to have a think about the bereaved partners paternity leave regulations. I did say there was a lot of P's in this. So the bereaved partners paternity leave regulations. This allows employees to take up to 52 weeks of unpaid leave as a day one right if the primary carer dies within the first year after the birth or the adoption. Again, we want to point out something with regards to sensitivity and the language that's used. In the legislation, the language is used as the primary carer, okay? And we want to always ensure that we've got to remember that that does not imply that fathers or partners are also not main carers, okay? And this legislation can also apply in a situation where an ex-partner passes away and somebody could then become eligible for this leave, even though they're not in a current relationship with an individual. Okay, so to be eligible, the father, the spouse, civil partner, partner of the mother, or indeed in an adoption situation as well, and it's also inclusive of same-sex parents. Okay. This leave must be taken within 52 weeks of the child's birth. It also applies to surrogacy situations or within 52 weeks of the child's adoption placement. I did say it gets quite technical, folks. You will obviously be able to access, Alexa, you able to share a copy of the slides after today so that you will have all of this information so you don't have to try and remember all of these facts. Okay, so with this legislation, an employee can have up to 10 keeping in touch days during that period of unpaid bereaved partners paternity leave. Okay, an employee also then has got enhanced redundancy protection. Okay, so if an employee has taken 6 weeks of bereaved partners paternity leave or more, they will have a priority right to be offered suitable alternative employment. okay, if they were selected for redundancy. And that extra protection is in place up until 18 months from when the child is born, or in adoption situations, 18 months from when that child is placed in adoption. If it's an international adoption situation, it's 18 months from the time that they enter GB, Great Britain. Okay. If an employee takes less than 6 weeks of bereaved partner's paternity leave, they have enhanced redundancy protection for the period that they are off on that leave. Okay. They also have protection from detriment and dismissal because they have taken or sought to take bereaved partner's paternity leave. And what this means is they can bring an unfair dismissal claim without having the current 2 years service that's required currently. That's obviously going to change as well from January 2027, where it will become a 6 month service to bring unfair dismissal claims. But with this protection, they don't need either of those lengths of service. Okay. Okay. Oh, sorry, I've just realized I've got one little extra bit to tell you. If the birth mother or the primary adopter passes away, and in the sad situation, obviously, then when the child could also die, okay, the father or partner who would have been entitled to bereaved partners leave may still take up to 8 weeks, okay, of bereaved partners leave in the 52-week period, okay. So there is lots of kind of those finer details of the law. So if ever in these situations, again, don't hesitate to reach out to myself. You'll have my email address, or indeed to reach out to Acas. Okay. And as with any legislation, then we do have requirements of a notice. The notice that's required for this leave depends on when the leave is going to start. Okay. So firstly, let's look at what an employee needs to do if they wish to take this leave within 8 weeks of the bereavement. So the time frame we're thinking about is here is 8 weeks. Okay. So firstly, they must include the three things at the top, which must be included in all notices, by the way: date of the bereavement, the start date of the leave, and the child's date of birth. And again, then placement for adoption or entry into Great Britain if it's overseas adoptions. So if starting within 8 weeks of the bereavement, that notice must be given orally or in writing, and before the employee is due to start work on the first day of the leave. Okay. If the leave is to start more than 8 weeks after the bereavement, okay, notice is slightly different. Okay, so notice must be in writing, and the employee must give at least 1 week's notice before they start their first day of leave. And if the leave is taken 8 weeks after the bereavement, then the notice must also include further information, which is the intended date of return to work, declaration that the leave is being taken to care for the child, and confirmation of the relationship with the child. So that's the legal requirements. Okay. Okay, so this next slide is a very light touch. And again, we're not expecting you to remember all of these finer details, but it will give you the awareness, okay? If somebody wants to change the start date, okay? So if they wish to change the start date, we also have this time frame of the 8 weeks to consider, okay? So firstly, how do they give their notice? If the new start date is within 8 weeks of the bereavement, notice can be given verbally or in writing. If the new start date is more than 8 weeks after the bereavement, then notice must be in writing. Okay. And then secondly, when do they give their notice to change? If the proposed leave start date was within the 8 weeks of the bereavement, notice must be given before the old start date. And also, if the new start date is within the 8 weeks of the bereavement, it must be given before the new start date. Okay. If the new start date is after 8 weeks of the bereavement, it must be given at least 1 week before the new start date. Okay. Okay. And what about then cancelling leave? An employee can cancel their planned bereaved partner's paternity leave, but they must give that notice in writing. Okay. And when must they give it? If the last leave start date was within 8 weeks of the bereavement, notice must be given before the start date of the leave. And if the start date was after the 8 weeks of the bereavement, notice to cancel it must be given at least 1 week before that date. Okay. So employees do have the ability to make those requests to change it or to cancel it. And with any of those then requests or notices, there does come that information with how it must be given and when it must be given. Okay. And then also with this leave, if somebody wishes to change their return to work date, because don't forget, these things will change and it can be hard to plan. And I think what we've got to remember with a lot of these things, it's about that interaction, that communication between the employee and the employer. Okay. So if they wish to return to work either earlier or later than planned, they must give written notice of the new return date. Okay. And again, we're coming back to this time frame of 8 weeks. So if the last notice of the return date is within 8 weeks of the bereavement, notice must be given at least 1 week before the old return date and at least 1 week before the new return date. If the last notice of return date is after 8 weeks of the bereavement, notice must be given at least 8 weeks before the old return date and at least 8 weeks before the new return date. So those are the changes from April of this year. Let's have a think about what employers need to do in terms of taking action in terms of any legislative changes. Okay, one of the first things is to consider reviewing and updating all policies to ensure that the information is accurate in accordance with current legislation and update any changes to the eligibility criteria, update any changes in terms of the notice periods and being able to change or cancel these leaves. Okay. When making changes to policies, employers should plan their communications with their workforce to ensure that it's clear and empathetic, and also that any individuals who are affected are kept up to date. And also then consider how to update any internal training documents, and also then consider how you're going to engage with your trade unions for consultation or staff networks. And also don't forget, we've got to think about how we can train managers to be able to confidently hold conversations around any of these types of leave. Also ensuring a more, and I suppose maybe more practical side of things, ensuring online systems, etc., are also ready for any changes. Many employers do offer over and above the statutory minimum, which might be things such as enhanced paternity leave or paid parental leave or enhanced pay for any of the leaves that do attract pay. Those are things that can be included in your contracts of employment. Many employers also find that they are a fantastic way of promoting your workforce and encouraging people to apply to your organization, promote your flexible working policies and procedures. They can be a huge way of attracting people into your organizations. And all of these family friendly legislation and your enhanced policies can help reduce staff turnover, reduce recruitment costs, can increase productivity through a much better work-life balance, and can enhance the reputation of you as the employers. And obviously then they're also in line with the expectations and the criteria of the charter. Okay, so those are the most recent changes. Okay, there are proposed changes to more of the family friendly legislation. So let's have a look at what those proposals are. So currently, the government is still conducting a review of family leave, and that takes into account the maternity leave, adoption leave, so all of those family friendly legislation that are already in place. They are currently reviewing evidence, okay? And evidence was gathered last year and they are reviewing it, okay? What's the purpose of this review? Okay, so there are kind of four objectives of the review of the existing system. A, how do these legislation support maternal health? So we're very much thinking about the physical and the mental recovery and the well-being of women during pregnancy and postpartum and in those early days, as well as throughout the days of childcare as well. Okay, and how we can support that maternal mental health. We're also then, these reviews also looking at the support for economic growth by keeping parents in work, by enabling and hopefully allowing people to still advance their careers after they start a family. Also aiming at kind of improving that gender pay gap and try and reduce that penalty that still exists when when we become mothers. Okay, that motherhood penalty is well documented, and this review is thinking about is there a way that that can be reduced. The other objectives of the review of the existing system is to facilitate the best start in life for babies and young children, and also to support parents to make balanced childcare choices that work for their family. So do keep your eyes open for further changes, and the legislation that is under current review is maternity leave and pay, paternity leave and pay, shared parental leave and pay, adoption leave and pay, unpaid parental leave, neonatal care leave and pay, and maternity allowance. So the review also then is thinking about how the current system is working for families and employers. And they are then listening to experts from not just the UK, but also from other countries. And they're trying to explore ideas for improvement to that system. So that's the current changes that are happening. And also, as I said, look out for future changes that could also be happening. Some extra support for you. Okay, so this is Acas support. Alexia might also be able to point you in the direction very shortly of I know there's lots of other support as well available from the charter. With regard to ACAS, our ACAS website, as I said, a wealth of information. We also provide lots of free services. So there is free online training, there is a wealth of information, there are free webinars, excuse me, our e-learning packages, our helpline, all of that is free. We also have paid services, so you can have a trainer come out and deliver training within your organization. We've got mediation, etc. So there's lots of services that ACAS provide, both free and paid.